Hello everybody, Roland Costea here. In this course, you will learn how to prepare for GDPR compliance either from your own company perspective, an employee working in the audit, compliance or cybersecurity department, or a private freelancer. This is a proven bullet print used by myself in my audits and also for my own company, and I will take you through all the necessary steps. The course is a complete A to Z, so we will cover everything that you need to know. In this way, we will first create the GDPR implementation plan as a first outcome. Then I will teach you the basic theory you need to know for being successful in front of clients or management, and also that will help you in achieving your CIPT certification. What is CIPT, you may ask? So, for the ones that do not heard about it, CIPT is the only technology-related certification for GDPR developed by IAPP, International Association of Privacy Professionals. And you may have the link of their site here that you can go and check what the requirements are for this certification. Then we will start and create every piece of document GDPR needs by a company example. So you will learn by doing what the GDPR auditor will ask you for. In the end, every report will end up with recommendations that usually involve technology that can solve GDPR challenges. In this way, I will demonstrate some security concepts by using different cloud technologies on Microsoft Azure as a matter of experiment for this course. The course is delivered in a mix of over-the-shoulder lessons and PowerPoint presentations. So either I show you clicks on the screen and how exactly you do different actions, or I present you the full concept using slides. On top of that, you will get downloadable resources that will help you in your journey. I strongly recommend that you go through every lecture one time and then go back to the beginning and start to take action. In this way, everything will get much more sense. As a student of this course, you will also get regular updates and access to new additional lectures as they are added. One more add-on for you, just being part of this course, you can write me a message and I can give you an incredible discount for my financial malware and QRadar courses that have good correlation with this topic, especially in the part related to how technology can help in achieving compliance. Now, let's get further and discuss about what you can expect in your journey as GDPR consultant. Hi guys! In this lesson, I want to show you the first touch of what you'll really get by completing this course, just because there are really valuable information, valuable templates, documents that we'll create and you'll have access to at the end of the course that will come a little bit later. And just because Udemy will ask you to provide the feedback for the course after the first 4 or 5 lessons, I want you to have the complete picture of how this course will look like. So for sure, we'll start with some theory with what the implementation guide and regulation is about, but we will go deeply into hands-on and we will create these documents that you may use as a template practically for your own company or for your own clients. So I want to show you to you right now what's really important. The GDPR gap assessment tools, and I have 2 different gap assessment tools that you will have access. This will be downloadable resources for you. And then we have the GDPR implementation guide that we will start discussing in section 2 and we'll end it up in section 7. So that's why I'm bringing this right now to you to show where the course will end up in the following lesson. So you need to be patient. You need to watch it just because the flow of the course, it has risen. So you need to understand some concepts that will help you understand how we will build these documents. But for the sake of this lesson, this is a GDPR assessment tool. So what we will see here, there are some chapters here on the left from the GDPR regulation and all the articles for those chapters. And here you have all the requirements. And practically what you do when you go for a client or for your own company, you practically assess all these requirements, if are met or no, and you mark it as a compliant and you set up an action required in order to achieve the compliance. The action can be sort of administrative access, or like nominating a person, defining a data privacy officer, and so on and so forth. Or it can be even sort of technical recommendations that may help in achieving the requirement. So this is a gap assessment tool. It gets all the important and practically all the lines, the requirements, and it stands up where in the legislation it's handled. It can be everywhere, or it can be in a specific paragraph and point, and sets up how the organization is compliant or not versus that specific chapter. And you may see here that we have plenty of information to be filled in. And what's the end result? So it's quite a lot. Now we are at chapter 6. These are more informational. Chapter 6, 7, 8, 9, 10, 11, final provisions. So these are more informational. So we'll stop more or less with a compliancy at chapter 5. Then you'll have some results in a separate tab that will say per chapters in how many requirements you are compliant or you are not compliant, and what it needs in order for you to match it. You have a chart then that will be filled in with info per chapter. How do you stand against the compliance? Right now I filled it with 100% yes, so that's why it looks the same. And then you have the percentage compliance for different areas for GDPR, and then there is more or less a radar in how do you stand in again based on the whole and the complete chapter. So right now this is one assessment that we may look and we may use, and I will provide you access to. The second assessment is the one made on 4 pillars: discovery, manage, protect, and report. So based on these 4 pillars, and you have different requirements over here, you may have subchapters, right? So you can go for all these subchapters and check the compliancy with. This gap assessment is made by Microsoft, and it's really cool to use because in the end you can create a Power BI business intelligence report that will, it's more like a dashboard that will look really nice in terms of compliancy, and I will show that to you in the end. Again, in the end of the section 7, beginning of section 8 maybe. So you have, like I said, all these areas here that you need to fill in with yes, no, or not applicable. And all these lines, all these requirements are bundled a bit different, going to focus on what means data discovery, data management, data protection, and data reporting. These are grouped a little bit different, but again, they are going for the same regulation. They are going for the same requirements. They have a different view in how you treat the legislation. In the end, the end result should be the same. The way you are presenting it, it's up to you. So you may use both of these tools, or you may use a mix of them, but easier, I believe, it's the first one that I showed you, just because it goes line by line with the legislation, with all the requirements, and it says what specific article is this focused on. And the last document that I want to show you is the GDPR Implementation Guide. We will follow up this guide with the introduction and the preparing for the GDPR. We will start with some theory. You'll understand the principles, the lawfulness, the consent, what are the rights, what is DPO and when to appoint one, data privacy impact assessments, supervisory authorities, which is the one that you should follow the guidelines for, codes of conduct and certification, and we will end it up in preparing for the GDPR, where we will develop some documents. Around 15 documents will be provided for you for this course, and others will be nice to have, and you will have an idea of where to look for in order to complete your documentation. So let's take this one by one. Let me just scroll down to the preparation. So you will have
the compliance evidence, the 2 GDPR gap assessment tools that I already showed you. You will learn how to create an executive support letter. You will have the GDPR preparation project plan, and with these 2 nice to have, you will have the GDPR roles and responsibilities. Then these regarding communication awareness and trainings are some ideas of documents and templates that will be nice to have. You can change based on your own companies. Regarding the personal data inventory, again, these templates are nice to have in terms of records retention, protection policies, personal data asset inventory with some examples. Regarding the rights of the data subject, then there will be provided privacy and personal data protection policy and data subject request procedures, with the others as nice to have. In terms of data protection impact assessments, you will have the process that will be provided with other forms that will lead you to how to complete this important process as part of GDPR. In terms of preparation for data breaches, it will be the incident response procedure, and I encourage you to go for my next training regarding the incident response in GDPR, and you'll have plenty of other really useful documentation over there. And the personal data breach notification procedure. Also in this training you'll have an example of how personal data breach will look like, and then you'll receive for sure the compliance of evidence and the procedure for international transfer of personal data.
So we will use this guide, and you'll have access to this guide, and we will run the processes of creating all these documents, and in the end you'll have a compliance evidence with all these documents that will map specific requirements from the GDPR legislation. How does it sound now? I hope you really enjoyed it, and I assure you this is valuable information that you cannot find in any of the online courses today. So I would really ask you for a real and concrete feedback about how do you feel about the training, taking into consideration what you'll get. It will really help me in becoming better and improving this training. If you feel something it's not okay, then write me a message. But take all of this into consideration when leaving a feedback. It really counts on me going further with this training on Udemy. Udemy trainings are part of my day-to-day life, and I will really appreciate an honest review from your side. Thanks a lot. Hello guys. In this lesson, we'll start discussing about a short overview of GDPR. The General Data Protection Regulation was approved by the European Commission on 27 of April 2016 and becomes law on 25 of May 2018. It replaces the previous European Commission legislation which dealt with data protection, which was called the Data Protective Directive of 1995. One of the major differences between the GDPR and the previous law is that the GDPR is a regulation rather than a directive. This means that it automatically becomes law in each of the countries that make up the European Union, without each of these countries needing to create their own individual laws. In contrast, the previous directive supposed that each of the member states needs to have a separate data protection act that needs to be passed by the relevant state legislative body to enact it. Whilst the emphasis is often on the rights of the data subject, when discussing the GDPR, it's important to remember that the European Commission is also trying to make it easier for organizations to share personal data and oil the wheels of businesses within the European Union, so it's not as one-sided as often thought. However, there are a number of important things to realize about the GDPR before we get into the detail. Firstly, it concerns the personal data of European Union citizens, wherever that data is held. This means that if your organization is not based in the European Union, but has customers or suppliers or third parties within it whose data you hold, the GDPR applies to you. Leading on from this, it means that if your organization doesn't look after the data in the way the GDPR requires, your organization may be subject to the penalties that the regulation allows. These penalties are a step change from previous legislation, and in serious cases they are designed to hurt. Third, if you do experience a breach of personal data, you have no choice but to tell the relevant supervisory authority about it. There are some caveats on that which we'll come to later, but keeping a serious data breach to yourself is no longer an option. But the mainstay of what the GDPR is about is forcing organizations to take the protection of the personal data of European Union citizens seriously. Hello guys! In this lesson, we will discuss about the format and some sort of definitions from GDPR that you should take into consideration. So the GDPR document itself is 88 pages long and consists of two main parts: recitals, 173 numbered paragraphs that lay out the principles and intentions of the regulation. If you like, you can call it the background. And articles, the 99 sections that set out the detail of the regulation. This is the part that must be complied with. In terms of definitions, the regulation provides 26 of the relevant terms, including the following, which I consider the most important to take care of. Personal data means any information relating to an identified or identifiable natural person or data subject. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an ID number, location data, an online ID, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. Processing means any operation or set of operations which is performed on personal data or on sets of personal data, whether or not by automated means such as collection, recording, organization, structuring, storage, adaptation or alteration, retrieval, consultation, use, disclosure by transmission, dissemination, or otherwise making available, alignment or combination, restriction, erasure, or destruction. Controller means the natural or legal person, public authority, agency, or other body which, alone or jointly with others, determines the purposes and means of the processing of personal data, where the purposes and means of such processing are determined by union or member state law. The controller or the specific criteria for its nomination may be provided for by union or member state law. Processor means a natural or legal person, public authority, agency, or other body which processes personal data on behalf of the controller. And consent of the data subject means any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data related to him or her. Hi guys, in this lesson we'll discuss about principles. The GDPR establishes a number of principles that underpin the legislation and are outlined using the following terms. 1. Lawfulness, fairness, and transparency. That means keep it legal and fair. Say what you are going to do with the data in clear terms. 2. Purpose limitation. That means you don't need to do more with the data than you said you would. 3. Data minimization. Don't collect more data than you need. Accuracy. Keep it up to date and deal with inaccuracies as soon as possible. Storage limitation. Don't keep the data for longer than necessary. Integrity and confidentiality. Keep the data safe while you have it. And 7. Accountability. Be able to show that you are complying with the principles above. If you keep all of these principles in mind at all times, you are unlikely to fall full of the GDPR. Hi guys, in this lesson we will discuss about lawfulness. For the processing of personal data to be lawful, it must meet at least one of a number of criteria, and an important first step in considering your processing activities is to clearly establish which of the criteria applies in any given situation. In essence, the criteria to choose from with regard to the lawfulness of the processing are as follows. The data subject has consented to it. 2. It's needed to perform a contract between your organization and the data subject or to see whether a contract can happen. 3. You legally have to do it. 4. You're protecting the vital interests of the data subject. 5. It's in the public interest. 6. It's for your legitimate interests, as long as it doesn't affect the data subject's rights and freedoms. So, whilst consent is an important aspect of the GDPR, it's not the only way in which collecting and processing personal data can be lawful. In fact, you may find that a significant proportion of the personal data your organization holds and processes doesn't require consent. Instead, it is required for lawful purposes such as providing support to customers, paying employees, or dealing with the tax authority. The process of obtaining and maintaining consent may involve changes to businesses' processes and systems, so it is a good idea to make sure there is no other lawful basis on which processing can take place first. Hi guys, in this lesson we will discuss about consent and rights of the data subject. When we speak about consent, if you believe that your processing is lawful because you have the data subject's consent, then you must be able to prove it. You can't hide the consent wording in amongst other contractual ramblings and expect to get away with it either. It must be an intelligible and easily accessible form in clear and plain language. Otherwise, the consent doesn't count and your processing could be judged to be unlawful. This is GDPR Article 7, Paragraph 2. Once given, the consent can be withdrawn at any time by the data subject, and this must be as easy to do as it was to give it in the first place. A child must be at least 16 years of age to be able to give consent, younger if a member state decides so with a lower limit of 13, otherwise parental consent must be obtained. Rights of the data subject. The GDPR establishes a set of rights that the data subject can exercise and which the controller holding their personal data must react and respond to, generally within a month. Here are the rights. So the right to be informed, being told what data will be collected, why, by whom, for what purpose, and where the data will go. The right of access, being able to see personal data that are being held about the data subject. The right to rectification, getting the data corrected if they are wrong or inaccurate. The right to erasure, having personal data removed when they are no longer necessary. The right to restrict processing, pausing the processing of the data if there are grounds to do so. The right to data portability, obtaining the data in a transportable form and moving it to an alternative processor. The right to object, stopping the data from being processed. And automated decision-making and profiling, having a human involved in important decisions. These rights follow on from the principles that we have discussed earlier and are aimed at ensuring the personal data is processed fairly and transparently, and that the data subject can do something about it if this doesn't happen.
Hi guys, in this lesson we will discuss about Data Protection Officer and Data Protection Impact Assessments. Depending on your organization and what it does with personal data, you may or may not need a Data Protection Officer. You will have to designate one if you are a public authority or body, you monitor data subjects on a large scale, or your large volumes of special category data are involved. Data protection officers may be part-time, may be shared across organizations, and may be external resources or services. They must remain independent, and their contact details must be freely available, especially to data subjects. The data protection officer is the main contact with the supervisory authority and is likely to get involved when key issues of data privacy and protection are addressed within the organization, such as during data protection impact assessments. The data protection officer will need to know a reasonable amount about data protection law in order to fulfill the role. In order to establish a culture where data privacy is baked into new processes and systems rather than added as an afterthought, the GDPR requires that data protection impact assessments be carried out where the risks involved to data subjects are reasonably felt to be high. This process involves understanding the personal data involved and addressing likely risks through the use of appropriate controls so that proactivity rather than reactivity is the order of the day.
Hi guys, in this lesson we will speak about codes of conduct certification and international transfers. The regulation makes provision for member states, industry bodies and other organizations to create relevant codes of conduct and certification schemes that can be used to encourage and demonstrate compliance. It's early days for such schemes, but they are likely to increase in popularity and availability as time goes by, so it's well worth keeping an eye on what's happening in your country and industry. Sending the personal data of European citizens outside the European Union raises questions over how well the data will be protected, and the GDPR places restrictions on how this may be done. To be helpful, the European Commission regularly decides which countries it trusts to look after EU personal data and publishes a list of those deemed to be acceptable. Currently, it's a small list, so you may need to look at the other ways to meet the GDPR if you need to do international transfers. Other ways that may get approval are a legally binding agreement, binding corporate rules, using standard clauses in your contract, or signing up to an approved code of conduct or certification scheme. If you are going to use binding corporate rules, be aware that they have to be approved by the relevant supervisory authority, and that can take a while. There are a few get-outs or derogations, as the GDPR calls them, for small, infrequent transfers, so it may be worth checking the list in Article 49 if time is not on your side. Hi guys, in this lesson we'll talk about penalties. Each country within the EU will have a supervisory authority which is responsible for overseeing the operation of the GDPR in that country. Generally, this already exists and will not change. However, if your organization is outside of the EU but wishes to process the data of EU citizens in several countries, you will need to choose the most appropriate supervisory authority to act as the lead for your organization. The GDPR establishes the European Data Protection Board to oversee the application of the regulation in the member states. Each supervisory authority has a seat on the board, together with the head of the European Data Protection Supervisor. The board will produce an annual report to tell us how well it's going. And so we come to the teeth of the regulation. The fines that can be levied for non-compliance with the GDPR are certainly larger than those for the directive it replaces. The actual amounts demanded will depend upon a wide variety of factors, including the personal data involved, how hard the culprit organization tried to protect the data, how much they cooperated with the investigation, and most importantly, the specific articles of the GDPR they are judged to have contravened. Fines allowable are up to 2% of global turnover, or 10 million euros, for lower-level infringements, and up to 4% of global turnover, or 20 million euros, for more serious cases. Data subjects can lodge a complaint with the relevant supervisory authority directly themselves or may use the services of a not-for-profit body active in the field of data protection. Hi guys, in this lesson we will discuss about securing management commitment. Before embarking on a project to achieve compliance with the GDPR, it is very important to secure the commitment of top management. This is probably the single most significant factor in whether such a project and the ongoing operation of the implemented process afterwards will be successful. The first questions top management are likely to ask about the project are probably: what are the requirements we must meet? How much will it cost? And when does it have to be in place by? Probably the most important point is that compliance is not optional and the potential fines are big. Senior management support for the project may be demonstrated by publishing a letter or a memo similar to the one we will create, and we call it executive support letter. And we'll start creating these documents in the chapter 7 of the course. So wait until this chapter, learn, process the theory, process what you have to do, and then we'll together start by doing effectively these documents and how we will become compliant. Then we will create the document compliance evidence that will show you how the various documents included in the report map onto the requirements and what other evidence may be appropriate to show compliance. This may help when deciding whether a requirement is met or not. In order to quantify how much work may be involved in complying with the regulation, we will create the GDPR Gap Assessment tool in 2 versions that I already showed you in the intro of this course. This summarizes the key points of the relevant sections of the regulation in question form and is intended to give you a reasonable idea of where your compliant and non-compliant areas are. Roughly 2/3 of the articles in the GDPR are aimed at bodies other than an organization trying to comply, so they aren't really requirements that you will need to worry about. These cover tasks such as the setting up of the European Data Protection Board, certification schemes, and the rules that the supervisory authorities in each member state must follow. Hi guys, in this lesson we will discuss about planning your project. Having secured top management commitment, you will now need to plan how to achieve GDPR compliance. Even if you are not using a formal project management method, such as PRINCE2, we will still recommend that you do the bare essentials of defining, planning, and tracking the implementation effort as a specific project. We have provided a template that we call project initiation document that we will fill in, and this one will prompt you to define what you are trying to achieve, who is involved, timescales, budget, progress reporting, etc., so that everyone is clear from the outset about the scope and management of the project. This is also useful towards the end of the project when you come to review whether the project was a success. Having written the project initiation document, try to ensure it is formally signed off by top management and that copies of it are made available to everyone involved in the project so that a common understanding exists in all areas. Other documents that we will create is the project preparation plan and the GDPR documentation log, but we will come back to this in the section 7 of the course, where we will go and fill and watch all these documents in more details. Hi guys, in this lesson we will discuss about GDPR roles, responsibilities and authorities. It's important to establish from the start who is going to do what, both within your initial project to comply with the GDPR and for the long-term protection of the personal data that you hold. The provided document that we'll create, GDPR Roles, Responsibilities and Authorities, in Chapter 7, sets out various roles, including an information security steering group to oversee the way in which data protection is controlled, an information security manager, and most importantly, information asset owners who have the most day-to-day involvement with the data in question. If not already allocated, decisions need to be taken about who will fulfill these roles, including potential recruitment. The only role that is explicitly mandated in the GDPR is that of the Data Protection Officer, called DPO. As we mentioned above, you may or may not need to appoint one of these. If you are a public body, there is no decision to be made, but otherwise you may need to get views from different perspectives within the business about whether you handle personal data on a scale that might be considered large. Your supervisory authority may be able to advise either directly or via their website if you are unsure about this. If you do need a DPO, you will need to decide whether to appoint internally share a resource with one or more similar organizations, or to contract a service from a third party. Make sure the person that is appointed has the relevant competence, including expert knowledge of data protection law and practices. GDPR Article 37, Paragraph 5. One of the other points you may need to clarify is the supervisory authority that you will report into. For single country organizations within the European Union, this should be a straightforward matter, but if your organization is based outside the European Union or you operate across borders within the EU, there is a decision to be made about who will be your lead supervisory authority. Remember that you will need to be able to justify this choice based mainly on where you do business the most, but there may be some flexibility if you have a preference. Hi guys, in this lesson we'll discuss about communication, awareness and training. Once you've initiated your project and defined who will perform which role, there is a lot of value in raising general awareness about the GDPR and information security in general, so that people know what it is and why it's important. Audiences will include various stakeholders such as suppliers and contractors, as well as employees, and it's useful to create a managed program of communication so that it happens regularly. You also need to identify the training needs of the people that are taking on the various roles involved in achieving compliance on an ongoing basis. This may be done by defining what competencies are required and then conducting a comparison exercise by questionnaire to find the gaps. This may be filled via a combination of formal and informal training, including courses, webinars, seminars, books, and of course reading the regulation itself. Training may typically be needed in areas such as data mapping, data protection impact assessment, and incident management. Some documents that you will need and it will be really useful to have will be GDPR communication program, the briefing presentation, some competence development procedure, questionnaires, the security awareness training, and some meeting minutes from all these appointments. Hi guys, in this lesson we'll discuss about personal data inventory. Once your people are in place and they've received some training, the next step is to do some analysis of the way in which personal data is currently collected, stored, processed, transferred, and disposed within your organization. There are many ways to represent this, but must come down to drawing diagrams of the flow and recording relevant information on a spreadsheet. You'll need to involve the people who are responsible for collecting and processing the data on a daily basis to ensure that as a full picture as possible is obtained. You could do this by arranging workshops and using whiteboards and sticky notes, or you could send them a spreadsheet and ask them to complete it, or you could do both, whatever fits the culture of your organization. What's key here is to understand the main facts, such as the data items that are being collected, for what purpose, by what method, for example on the website, face-to-face, paper form, where, how, and for how long the data is stored and where it gets sent to. This will help in identifying any additional controls that need to be applied to it, such as encryption, and in establishing the legal basis under which it may be collected and processed. The overall approach you decide to take regarding data retention can be reflected in the records retention and protection policy. Some documents that will be useful, and we'll start looking at them and creating one of these, are Personal Data Asset Inventory, Records Retention and Protection Policy, Personal Data Mapping Procedure or Capture Form, and even Mapping Diagram or Flow Mapping Tool. Hi guys, in this lesson we'll discuss about the rights of the data subject. Making sure you allow the rights of the data subject to be exercised without hindrance is an important factor in GDPR compliance, and one which may attract the attention of the supervisory authority if not done properly. The most effective way to allow the data subject to access and maintain their personal data is likely to be via some form of portal that the user can log into via the internet and do it directly themselves. Similarly, standard forms may be provided via such a portal for requests such as objection and processing restrictions. You will need to make sure you have the appropriate workflow behind the forms to ensure they are logged correctly, processed by the right people within the required timescales, and that the identity of the requester is confirmed. Some requests will require decisions to be made, and sometimes this will not be straightforward. So having a clear process and roles will be important, and you will see that in the data subject request procedure that we will use. You will also need to consider the best way to communicate your privacy notice to the data subject, making sure that it covers the information required by the GDPR. We provide a procedure and a planning form for this purpose also. Again, the best ways to do this will depend upon how you interact with your data subjects via internet, telephone, face-to-face, etc. Some documents that we will use, and it will be nice for you to have in the GDPR compliance, are Privacy and Personal Data Protection Policy, Data Subject Request Procedure, Data Subject Request Register, Request Form, Privacy Notice Procedure, and Privacy Notice Planning Form. Hi guys, in this lesson we'll discuss about data protection impact assessments, personal data breaches, and records of processing. Data protection impact assessments. This is a relatively new area for many organizations, but one which is clearly mandated by the GDPR. New projects and significant changes to existing processes will need to carefully consider the impact on personal data as part of their assessment and planning, with appropriate controls put in place based on a fair assessment of risk. If you have a project's process, then this will need to be added to it. The GDPR states that this is necessary only where there is a high risk, but you may find that it is a good idea to perform these assessments as a matter of course for every project. Documents that you need to have and it will be useful for GDPR compliance are Data Protection Impact Assessment Process, Questionnaire, Workbook and Report, and GDPR Assessment Procedure and Form for the suppliers. Regarding personal data breaches, the general consensus within the information security industry nowadays is not if an organization will suffer a security breach, but when, and it may already have happened, but you just don't know about it. So having an appropriate and tested incident management procedure is a must. The procedure offered as a template is a good starting point for incidents affecting not only personal data but for a range of information security events, including denial of service attacks and ransomware. The GDPR insists that your supervisory authority be told about known breaches that represent a high risk to data subjects, and is specific about the timescales and the information that must be provided. We provide a notification procedure form and register which should help to speed things if the worst does happen. Documents that we'll use and create are the Information Security Incident Response Procedure, Personal Data Breach Notification Procedure, Personal Data Breach Notification Form, and Register. Regarding the records of processing, your supervisory authority could at any time ask to see records of the processing of personal data that you carry out. So it's a good idea to be clear from the outset about where this information is to be found. We suggest keeping a spreadsheet of the main items of information, but you also need to be aware of the records such as logs and audit trails that exist at a lower level, reflecting the detail of what was done when. The full picture for GDPR purposes will consist of a wide variety of items such as data protection impact assessments, privacy notices, subject request registers, data mappings and risk assessments, which together reflect how seriously the protection of personal data is being taken within the organization. This will become particularly important in the event of a data breach when the supervisory authority comes to decide the level of penalty that might be appropriate. Documents that we'll use are record of processing activities and compliance evidence. Hi guys, here we are at the end of this chapter. So what I want to say is that you will get two resources as part of this last conclusion lesson. One that will be the GDPR implementation guide that you see over here, and this is practically the document that fills in all the lessons we discussed in this chapter. So you will have a document that you can use for your own company or for your own clients in an audit that will summarize what we discussed and put it in a proper table of contents. So as you may see here, you have everything from the formal definitions, principles, authorities, roles, DPOs, impact assessments, and how to prepare for that. So this is practically all the lessons from this chapter that we discussed. Put it in a normal and great format that you can start reusing it immediately. So this is one of the resources that you will get access to. And the second one, it's the last version of the regulation. It's not so easy to find. For sure, you can find it online and download, but it's not so easy to do it. So I decided to add it as a resource for this lesson. So you can start reading it. You will see there are a lot of things here to as an introduction to understand what the European Commission means by data privacy. A lot of things over here, and you'll start up to the middle, I think. Let me just find it. To fill in and to find and read all the requirements that you need to process and you need to be compliant with in your GDPR journey. But let me just find it. Oh, it's over here. So here is the chapter 1. So it's page number 32. So there are general provisions, different articles, territorial scope, and all these principles related to processing, personal data, lawfulness. If you remember, conditions for consent, all the lessons that we discussed are mapped directly to the legislation, directly to the law. Processing of special categories, and you'll find all the requirements you will need to comply in. What we'll do in the section 7 is we will get all these requirements and we'll try to put it in a decent and nice Excel form and define what will be compliant and non-compliant based on the requirements. So you'll use the compliance of evidence, we'll use the gap assessment, and then different other documents that will help us address the gap assessment. So keep you posted. It will follow up with 3 sections for pure theory that will let you understand what we really mean by data privacy and how technology can help from time to time. And then we'll start creating documents and we will end up the course by some demos with technologies that can help us achieve the compliance. So keep you posted.
Hi guys, in this lesson we'll discuss about foundational elements for embedding privacy in IT. Without privacy policies in place and proper training for employees, it is extremely difficult to ensure that employees are following proper privacy practices. An organizational privacy policy is the first essential piece of collateral material needed for an effective privacy program. The privacy policy must come before a privacy notice is created, as the notice is a reflection of a company's privacy policy. Likewise, setting up privacy training is not practical until a policy is in place. Let's take a look at organizational privacy notice. The privacy notice is an external instrument that informs the outside world about an organization's privacy practices. It is a reflection of the organization and its commitment to privacy and can affect its brand. It provides transparency for consumers and comfort for privacy advocates. In some jurisdictions, it's a legal requirement. The sheer size of a privacy notice can be daunting to the average website visitor. Having a privacy notice that fits on the one page and covers the most important aspects of an organization's privacy practices will go a long way towards setting the website visitor at ease. There are a list of sections that should exist in a privacy notice, and they include information that consumers as well as privacy advocates and regulators will want to know about. Organizations with fewer or more complex data handling practices may require fewer or more sections. What data is collected? This is one of the most important pieces of the privacy notice, as it lets everyone know what data is collected and by extension what data is not collected. This declaration should include data that is observed, inferred, and declared directly from users, as well as data collected from third party. How collected data is used? This section describes how collected data is used across the organization. It should provide a general description of data usage, including how the data may be used by all groups across the organization. How collected data is shared. This section should cover how data is shared not only outside the organization but with which teams across the organization. User control over collected data. This section should describe how users can control the collection and use of their data. There should be a description of any preference or configuration management system that will help users manage how their data is collected or used. Controlling marketing contact. Users should be able to control how and when an organization contacts them. Service and transactional emails are expected when an individual creates a relationship with an organization or purchases a product. However, those same individuals should not have to be subjected to marketing emails in order to receive service emails. Use of cookies and other tracking mechanisms. Cookies are the main mechanisms by which organizations keep track of visitors to their websites. However, companies may use flash cookies, locally stored objects, HTML5 storage, fingerprinting, or some other means to track users. A description should be provided to users about the tracking mechanisms. Gaining access to data. The notice should explain how users can access the data an organization holds on them. Resolving privacy issues. This section should describe how users can resolve privacy issues they may have within an organization. This can be handled via an online form, email address, phone number, or postal address. Date of privacy notice and changes to privacy notice. Users should be made aware of how often a privacy notice may be changed and how they will be informed of changes. Users should be also provided with a means to see previous versions of a privacy notice. Let's now take a look at the organizational privacy policy. The privacy policy is the guiding set of privacy principles used by teams within an organization to help them understand their privacy obligations as they develop software and services, create marketing campaigns, work with vendors, and engage the general public. Privacy policy also serves as a guide for all organizational activities and drives the commitments made within the privacy notice. Because of the eventual impact of the privacy policy, those creating it should be careful not to make the policy overly prescriptive and/or restrictive, as this could limit the business potential of some groups. The organizational privacy policy should provide general guidelines while leaving business groups the flexibility to provide more prescriptive rules that support their business goals. An organization's privacy policy should at a minimum cover the following topics: types of data classification, data collection principles. This description should indicate the notification, control, protection requirement, minimization requirements, and sharing limits for collected data. Protection of data. The type of protection required, be it encryption or access control, will typically vary based on the classification of the data. Data retention period. Treatment of sensitive data. The definition of sensitive data can be elusive as everyone has a different idea of what is sensitive, and that can change with context. Most jurisdictions agree that specific medical and financial data is sensitive. However, religion, political views, ethnicity, sexual preference, and entertainment choices can be considered sensitive to certain people and locals. Sharing of data across groups. A policy should describe the management of data as it is shared across groups within an organization. It is important that the policy take into account the privacy commitments made at the time by the group originally collecting the data. Sharing of data with partners and vendors. Creation of departmental privacy policies. Groups within an organization will often create a privacy policy that covers their specific processing of collected data. These policies must not conflict with the organizational policy. The organizational privacy team should be involved in the sign-off of departmental privacy policies. As the organization's privacy policy evolves, departmental policies must be updated to reflect any changes that might impact these policies. Performance of privacy reviews. A privacy policy should outline when and how privacy reviews should occur. Participation in a privacy response center. All organizations should have a privacy response center in place that responds to external privacy incidents. The privacy policy should detail how groups within the organizations should be involved in the privacy response center and indicate the obligations of each group in response to a privacy incident. Responding to privacy inquiries. Privacy inquiries can be received by organizations that are not caused by a privacy incident. Regulators, consumer advocates, or journalists may have general questions about an organization's privacy practices, notifications, or plan. The privacy policy should describe how privacy inquiries will be handled and who should be involved in the response to privacy inquiries. and responding to data requests. Data requests can come from users who own the data, law enforcement agencies or third parties wishing to have access to data. An organization's privacy policy should indicate the conditions under which data requests will be honored and outline the process for verifying the rightful owner of the data. Let's take a look at the organizational security policy. Organizational security policies help to protect an organization's infrastructure and vital resources. It is the security policies that help maintain an organization's privacy policies. An organization should go through a security review to determine where its risks are. Performing a privacy impact assessment, which will be discussed later, can help identify where security practices will need to be applied in order to mitigate privacy risks. An evaluation should be done for every data source to understand what security measures need to be in place to protect it. Sometimes simply putting in adequate access control is enough. At other times, more advanced access controls, password protection, encryption, and isolation techniques may have to be deployed. We'll discuss about 4 areas: access control, encryption, password control, and intrusion detection. Regarding access control, this is a mechanism by which access permission to a resource is managed. An access control list, or ACL, consists of a series of access control entries. Each entry contains the name of an entity and the type of access the entity has to a particular resource. There are different types of access controls that may be implemented on a system. Discretionary access control is a mechanism by which a user has complete control over all the resources he or she owns. It's called DAC or DAC. Mandatory access control is a mechanism where only the administrator can assign access rights to a resource. Role-based access control manages an entity's access to resources based on organizational roles. And attribute-based access controls is an extension of role-based access control in that it permits the addition of attributes to refine an entity's description. Encryption is an important tool for protecting sensitive data. 2 examples of encryption, SSL protocol and TLS protocol, help to protect data that is transmitted directly from client to server machines and server to server machines. SSL is commonly used to protect communications between a browser and web server. TLS is often used to protect email as it is transmitted between email servers. For protecting data at rest, symmetric and asymmetric encryption can be used. Hashing is also a method of protecting data that uses a cryptographic key to encrypt, but does not allow the data to later be decrypted. Password control. Access to computers, files, databases, websites, networks, and other resources containing sensitive data can be controlled by a password. Each resource can be accessed using a separate user account with its own ID and password, or a single sign-on mechanism can permit access to multiple resources using a single user account. Intrusion detection. Attacks on data can come from external entities wishing to gain access to an organization's network resources. Organizations big and small are constantly under attack from outsiders desiring access to organizational data. All of these exploits can cause threats to an organization's privacy resilience. To protect themselves from external threats, organizations should deploy intrusion detection systems. Let's discuss about incident response, security and privacy perspectives. Having a mature incident response program is an important part of any privacy program. Sometimes it is the only way that an organization's customers can submit a privacy issue. The incident response program should consist of an incident response center, web form, email address, phone number, and representatives from public relations, legal, privacy, and security. The privacy response form should be easily accessible from the organization's privacy notice, as well as easy to use. Providing a selection setting with privacy categories is one way to simplify the requests. I am kindly inviting you to take a look at my full course regarding incident response and GDPR, and you will find a lot of useful information as well as documents that you may use in your incident response process. Let's take a look around security and privacy in Systems Development Lifecycle, or SDLC. The Systems Development Lifecycle consists of several phases from project initiation to maintenance or disposal.
Including security and privacy evaluations at each phase in the SDLC helps to streamline the process and save time overall. For privacy, privacy by design should be incorporated into the process. Also, the collection, processing, sharing, and retention practices of the data should be analyzed. To ensure security risks are mitigated, an analysis of access control, intrusion detection, and resource protection measures should be made. Let's take a look at the enterprise architecture and data flows. According to Gartner, enterprise architecture is a discipline for proactively and holistically leading enterprise responsive to disruptive forces by identifying and analyzing the execution of change toward desired business vision and outcomes. EA delivers value by presenting business and IT leaders with signature-ready recommendation for adjusting policies and projects to achieve target business outcomes that capitalize on relevant business disruptions. EA is used to steer decision-making toward evolution of the future state architecture. Data flows should be designed such that they maximize utility of organizational data while maintaining compliance with organizational responsibilities. A data flow diagram, as the one in the slide over here, provides a graphical means to illustrate the flow of data across an organization. The diagram can show the origin of data, indicating whether the origin was an individual, external entity, internal group, or process. It can show which processes and data stores are involved in a data flow, how the data may evolve as it flows across processes, and even where data might flow across geographical borders. Let's take a look at Privacy Impact Assessment, or PIAs. The PIA is one of the most important parts of a privacy program. It helps an organization identify its privacy risks and measure the criticality of each risk. The result of the PIA can facilitate an action plan for addressing each risk. In a small organization, the privacy team can perform the risk assessment. In large organizations, the risk assessment responsibilities may have to be spread out across teams. Using the assistance of external party can help to streamline the process. Risks can be addressed in several ways: avoid, mitigate, accept, or transfer. Avoid risk. The organization can decide that it will no longer process credit card transactions. Instead, it will rely on a third-party service to process them. Mitigate risk. The organization can decide to encrypt the credit card number during collection and storage and place tight restrictions on access to credit card data. Accept risk. The organization can decide that it would be too costly to use a third party to process its credit card transaction or to modify systems to encrypt the numbers. It may instead rely on current practices to protect the credit card data and hope for the best. Or transfer risk. The organization can purchase business insurance to cover the firm in the case of a data breach. Hi guys, in this lesson we'll discuss about common privacy principles, or the 8 do's. Each organization should govern itself by a core set of privacy principles that cover how personal information under its control is processed. These principles can serve as a framework for employees to follow as they develop their internal policies. Collection limitation is the first one. This principle covers the restraint from the excessive collection of personal information. Organizations should limit the amount of data they collect in order to minimize privacy risk and legal liability that can come from excessive data collection. Data quality. This principle covers the idea that organizations that collect personal information should make efforts to maintain the quality of the information. When collecting personal information, organizations should ensure that they have collected all the information that was requested and that the information is not modified during transmission or storage. Purpose specification. This principle covers the expression of purpose for which personal information is collected. Whenever personal information is collected, the purpose for its collection should be expressed to the individual. This notification should be provided to the user before the collection. Once the data has been collected, the purpose for its collection should not change without providing notice to the user and obtaining consent to apply the new purpose to the previously collected information. Use limitation. This principle covers the idea that the use of personal information should be limited within an organization. any usage should be covered by the privacy notice in effect at the time the personal information was collected. Security safeguards. Organizations have an obligation to provide security for the data they collect from users. The level of security should match the sensitivity of the data being collected. For aggregate data that simply lists the number of site visitors and the pages they viewed, a low level of security is probably okay unless it is critical business data. Openness. The principle encourages organizations to be open about the personal information they collect and the privacy principles that govern their treatment of such information. Individual participation. This principle provides the ability for an individual to receive confirmation from an organization that the organization holds data collected from or relating to the individual. If such data exists, the individual should have the right to request and receive such data from the organization in a timely manner and at a reasonable cost. Upon granting the data request, the organization should deliver the data to the individual in a format that is intelligible to that person. Accountability. This principle covers the idea that whenever an organization plans to transfer an individual's personal information, it should obtain consent from the individual or exercise extreme care in handling the personal information. So, as a conclusion, a great house starts with a great foundation. The bigger the house, the better the foundation must be. If a company wants to be great at privacy, it must begin with the foundational elements of privacy.
Hi guys, let's discuss about legitimate interest. Another frequently relied on basis for lawful processing of HR data is that it is in the legitimate interest of the business to do so. Under the GDPR, processing will be lawful where it is necessary for the purposes of the legitimate interest pursued by the controller or by a third party, except where such interests are overridden by the interests or fundamental rights and freedoms of the data subjects which require protection of personal data, in particular where the data subject is a child. Well, until recently, the equivalent provision in the DPD was heavily relied on by employers to justify data processing, but recent case law from the Court Justice of the European Union has made it clear that you cannot simply argue that you have satisfied the legitimate interest test because it is in your economic interest to process the data. So, for example, there may be a legitimate interest in monitoring employees, but in order to help ensure that the employer's interests are not outweighed by the rights of the employees, there must be full transparency about what monitoring takes place and for what purposes, together with appropriate safeguards. Well, necessary for a performance of a contract or to comply with a legal obligation, and let's debate about that. Processing will also be lawful where it is necessary for the performance of a contract to which the data subject is a party or in order to take steps at the data subject's request prior to entering into a contract, and this includes employment contracts. And also, for example, where it is necessary in order to comply with a legal obligation. These grounds are helpful to employers, but they should remember that the purpose limitation and data minimization principles will apply and may have a bearing on how much data may be collected and what it can be used for. Will all member states approach employment data in the same way? Well, although the GDPR provides for a more uniform approach to ensuring data protection compliance across Europe, there are of course permitted derogations. One such example is Article 88 of the GDPR, which allows for member states, by operation of law or collective agreements, to provide more specific rules to safeguard the processing of employees' personal data within the employment context. The article further sets out that this may be in relation to data processed for a variety of purposes in the employment cycle, from recruitment to health and safety at work. the extent to which member states choose to exercise these derogated powers to reflect their current practices or to strengthen protection around employee personal data remains to be seen. So, what does this mean in practice? Employee consent to the processing of their personal data is unlikely to be held to be valid under the GDPR. Employers should begin looking now at the grounds on which they have processed HR data to date and consider whether these need to change under GDPR. The most likely ground for lawful processing of HR data will be that it is in the legitimate interest of the employer to do so. In order to ensure that the rights of employees are not unfairly compromised, there must be full and transparent disclosure of what data processing is taking place and for what purposes. While identifying an alternative lawful ground for processing is unlikely to be difficult in the employment context, the purpose limitation and data minimization principle may restrict the range of employee data which can be collected and what that data can be used for. Employers will need to give thought to each separate category of employee data, and which they process for sure, and record the grounds for lawful processing upon which they rely in each and every case. Hi guys, let's discuss about changes to employee data management under GDPR. Well, as the implementation of General Data Protection or GDPR approaches, businesses need to consider what this might mean in terms of cultural, structural and practical changes that may be needed in order to meet the new requirements, particularly in relation to employee data, likely to be the biggest risk area for many employers. Many of the concepts under this new GDPR, while new for the UK and some European Union member states, are not so new for others. Germany, for example, has been at the cutting edge of data protection developments, and a number of the requirements under the GDPR either reflect current German practice and thinking or are not far removed from them. Increased employee rights under the GDPR, employees as data subjects will have greater rights. The good news for UK employers is that many of these rights are similar to those under the current UK Data Protection Act from 1999. The bad news is that as a general rule, the GDPR expands the rights under the DPA, introduces a few new rights and imposes significant penalties for breaches. In summary, under the GDPR, employees as data subjects have the following rights. The right to be informed, which encompasses the obligation on employers to provide transparency as to how personal data will be used. The right of access, similar to those rights under the DPA and encompassing the ever-popular subject access requests. The right to rectification of data that is inaccurate or incomplete, again similar to the DPA, the right to be forgotten under certain circumstances, and the right to block or suppress processing of personal data, similar to the DPA, and in the end, the new right to data portability, which allows employees to obtain and reuse their personal data for their own purposes across different services under certain circumstances. Accountability and privacy by design, and let's discuss about that. Accountability is arguably a continental concept at its core and not necessarily a concept that the UK or newer member states are that familiar with. The new accountability principle requires businesses to demonstrate that they comply with the data protection principles and states explicitly that it is their responsibility to do so. In practice, this means that employers will have to put in place appropriate measures to ensure that They demonstrate the compliance, and this may include internal data protection policies, such as, for example, staff training, internal audits of processing activities, and reviews of internal HR policies. Then maintain relevant documentation on processing activities. Then, where required, appoint a data protection officer or DPO. Then implement measures that meet principles of data protection by design and data protection by default, such as data minimization, pseudonymization, transparency, allowing individuals to monitor processing, and creating and improving security features on an ongoing basis. And the last one, use data protection impact assessments where appropriate, as well as the obligation to provide comprehensive, clear, and transparent privacy policies. If the employer has more than 250 employees, it must maintain additional internal records of its processing activities. This is likely to place further costs and administrative burdens on employers. At the heart of the GDPR is a change in focus from high-risk matters to more routine ones, effectively on anything that impacts a data subject. Hi guys, let's discuss about DPOs and data protection impact assessments. Again, DPOs are arguably a Franco-German concept and something that German employers are probably more familiar with than their European Union counterparts. Under the GDPR, DPOs must be appointed by employers who are a public authority, except for courts acting in their judicial capacity, who carry out large-scale systematic monitoring of individuals, for example, online behavior tracking, or who carry out large-scale processing of special categories of data or data relating to criminal convictions and offenses. The DPO role can be outsourced to external providers, but the underlying obligation is that the responsible individual must have expert knowledge of both data protection regulation and requirements and of the practices and processes of the employer itself. This should be proportionate to the type of processing the employer carries out, taking into consideration the level of protection the personal data requires. Employers must ensure that DPOs report to the highest management level. Ordinarily, that should be the board level. They should be aware that adequate resources are provided to enable DPOs to meet their GDPR obligations, and DPOs operate independently and cannot be dismissed or penalized for performing their tasks. DPOs will have specific rights and protections: the power to insist on company resources for data protection matters, the right to access the employer's data processing personnel and also the operations, and express protection against dismissal or penalty for carrying out their duties. The last point is probably the most uncomfortable for employers, creating a protected class of employee, and one that US parent companies in particular are likely to find difficult to understand. There will be no limit on the tenure of the DPO role, which again is likely to cause raised eyebrows among some European Union employers. Employers should note that any organization is able to appoint a DPO, regardless of whether or not the GDPR requires the DPO to be appointed. Employers must ensure that they have sufficient staff and skills to discharge their obligations under the GDPR. Let's talk about data protection privacy impact assessments. These can help organizations identify the most effective way to comply with their data protection obligations and meet individuals' expectations of privacy. Employers will be required to carry out the personal impact assessments if their proposed activities are likely to result in a high risk to the rights and freedoms of individuals. This will affect various aspects of HR activity, particularly in the recruitment and post-employment arenas. it is easy to see how vetting and assessment activities in recruitment, for example, will trigger a personal impact assessment. Hi guys, let's discuss about data breaches and what to take away from that. Regarding data breaches, there are some positive actions that are most trivial for all the breaches. Employers will need to inform the relevant regulator of a personal data breach within 72 hours of becoming aware of the breach, unless they are able to demonstrate that the breach is unlikely to result in risk to the individual's rights and freedoms. While self-reporting has always been an option for employers to mitigate the risk of enforcement action, this has now become an obligation on employers for, arguably, all but the most trivial of breaches. In tandem, the ICO and other national regulators will also have increased investigations and audit powers and rights to require information and access to premises. The reason to care. Penalties currently fines under national member states law really vary. Under the GDPR, however, fines will be significantly increased across the European Union and will be levied on a two-tier basis as follows. Up to 2% of annual worldwide turnover of the preceding financial year or 10 million euros, whichever is greater, for violations relating to internal record keeping, data processor contracts, data security and data breach notification, data protection officers and data protection by design and default, and up to 4% of annual worldwide turnover of the preceding financial year or 20 million euros, whichever is greater, for violations relating to breaches of the data protection principles, conditions for consent, data subject rights, and international data transfers. In short, employers who previously regarded non-compliance with European Union data protection law as a low-risk issue will be forced to re-evaluate their position. Multinational employers also need to closely monitor developments in other member states, such as Germany, where lawmakers have already stated their intention to make use of the GDPR derogations for employee data protection. Some member states may raise the bar for local HR operations in certain areas, example lower thresholds for appointing an DPO and determining specific conditions for processing of a national identification number. What to take away from that? Well, employers need to take notice of the ways in which they process employee data, the purposes for which they process employee data, and the processes and procedures in place in their organization for the collecting, transferring, and storing employee data. The UK's ICO has taken a pragmatic approach to enforcement and is unlikely to change that. Maximum fines are likely to be imposed only as a last resort. However, other regulators may also have a say in enforcement against UK businesses, for example, where it is primarily their own citizens who are impacted, and this means the decision may not be the ICOs alone. In order to tackle these requirements and best protect the business, I recommend the following steps. Review current data protection policies and practices. Allocate appropriate resources to deal with the enhanced compliance burden. Then review employee data flows, use of employee data and ways in which data is processed and stored. Put in place updated or new internal data protection policies, staff training, internal audits, processing activities and audits of processing activities, and reviews of internal HR policies. Then assess business needs and identify employees who will require early training on the new reforms with a view to rolling out revised data protection training for all employees nearer to the date of implementation. where appropriate, appoint a data protection officer or DPO and or nominate an individual or officer to oversee compliance with the reforms, implement measures that meet the principles of data protection by design and data protection by default, use personal impact assessments where appropriate, and the last one, review and implement policies for reporting future data breaches, which should tie in with whistleblowing procedures. Hi guys, in this lesson we will define how all the topics and rights discussed before apply to HR recruiting and how this process is affected. What are the basic GDPR terms and how do they relate to recruiting? In respect to the recruiting function, the GDPR refers to candidates or data subject. Candidates are the data subjects because they can be identified through personal data they give to companies. For example, their resumes may include their names, physical addresses, or phone numbers. The GDPR exists to protect this kind of data. Members of hiring teams are also considered data subjects under GDPR, but their own data will not be processed in the same extent that candidate data will. Employers or data controllers. Employers or recruiters who serve as their company's main representatives to candidates determine the purpose of collecting candidate personal data. This makes them the data controllers, who are fully responsible for protecting candidate data and using it lawfully. And then it's the applicant tracking system or ATS and other recruitment software services or data processors. Your ATS is a data processor because it processes candidate data on behalf of your company following your company's instructions. Data processors often have subprocessors, and we discuss more about subprocessors in our course related to GDPR Cloud Service Providers or CSPs. So how does the GDPR affect recruiting? Here are few key directives of GDPR that affect the daily work of recruiters and also the hiring teams. 1. You need legitimate interest to process candidate data. GDPR obliges you to collect data only for specified, explicit, and legitimate purpose. This means, for example, that you can source candidate data as long as you collect job-related information only and you intend to contact source candidates within 30 days. 2. You need to have candidate consent to process sensitive data. GDPR requires you to ask for consent when you want to process data like disability information or cultural or genetic or biometric information or even information gathered for a specific survey or a background check. In these cases, you must ask for consent in a clear and intelligible way and provide candidates with clear instructions on how to withdraw their consent if they wish to. You need to be transparent about processing candidate data. Companies must have clear privacy policies and recruiters are obliged to make those policies available to candidates. You must also disclose where you store candidate data, for example your ATS, and state that you will use this data for recruitment purposes only. You need to assume responsibility for compliance. This is accountability. Your company needs to be able to demonstrate compliance with the GDPR. For example, under GDPR, your company is responsible for who it does business with. For example, an ATS provider or sourcing services. If your contractors fail to comply with the law, your company is accountable as well. Also, you are obliged to comply when candidates exercise their rights under GDPR. 5. Candidates have the right to be forgotten. Candidates have the right to ask you to delete and stop processing their personal data.
you must locate every place that you keep their information, for example spreadsheets, and delete it within 1 month after receiving the candidate's request. 6. Candidates have the right to access their data and ask you to rectify it. Candidates have the right to ask what data of theirs you hold. They can also request that you make corrections to any inaccuracies and rectify that. You must grant both requests within 1 month and provide candidates with a free electronic copy of their own personal data. Hi guys, sourcing is an essential function for organizations that want to find great people. However, sourcing requires finding and storing personal candidate data, so complying with GDPR all the way is critical. First, keep in mind that you need legitimate interest to source candidates and process their personal data. So ensure that you, 1. actually intend to contact those candidates. Simply building your talent database by adding candidate data in case you need it in the future is not legal under GDPR. 2. Plan to contact candidates as soon as possible. You can only keep a candidate's data without informing them for a limited time, a month at most. Contact these candidates as soon as possible and delete their data if they ask you to. If you change your mind about a candidate and decide not to contact them, you must delete their data immediately. 3. Collect only the data you need. You may want to process candidate data relating to education, work history or skills along with contact details. These types of data make sense for your recruitment process. However, you should not process irrelevant data, for example cultural information, for recruiting purposes. If you need to process this data, make sure to explain it when you contact candidates and ask for their consent. 4. Obtain data lawfully. Gathering data from social profiles is legal under GDPR if those profiles are publicly accessible and if you can reasonably assume that candidates expect to be contacted. For example, you may assume that a publicly accessible LinkedIn profile indicates a reasonable expectation of contact. Only then you can proceed to process candidate data. You need to create a template that you can add to your sourcing emails. If you have a recruitment-specific policy in place, you can provide your organization's name and contact details. Say that you intend to keep data for recruitment purposes only and link to your recruitment privacy policy to convey the rest of the necessary information. If you don't have a recruitment privacy notice yet, you need to include all information required by GDPR Article 14 in your email. You can also find in the resources area of this lesson a sample email text with placeholders. Hi guys, let's discuss about the job application process. Well, when candidates fill out your job application forms, they provide you with their personal data. Because job applications correspond to actual job openings, you have legitimate interest in processing this data and you do not need to ask for explicit consent. But to be fully compliant with GDPR, you need to ensure the following. 1. Ask only for personal data that you need. The Working Party 29, the collection of data protection authorities, states that the data you collect from candidates must be necessary and relevant to the performance of the job which is being applied for. 2. Be transparent. In your job ads, let candidates know that you intend to use their data for recruitment purposes only and how long you may need to keep this data. If you plan to gather more information about candidates, for example by reviewing their social media profiles as part of your screening process, you need to say that explicitly and explain how and why. 3. Link to your privacy policy. Your company's privacy policy should be easily accessible. It should include instructions to candidates on how they can ask you to delete, rectify, or stop sharing their personal data. In your job ad, let candidates know that they can find that information in your privacy policies. Let's discuss now about your rejection email templates and why you need that. Sometimes you have more than one great applicant for a role. If you can't hire all of them, you may want to keep the ones you didn't hire on file for future roles. To remain compliant with GDPR, you need to make sure that you will not keep this data for a longer period than the one you originally mentioned to candidates. If, for example, you told candidates in your sourcing email that you would keep their data for a year after they apply, you don't need to send them another email until that year has passed. Conversely, if you told candidates you would keep their data until you filled this particular position, then you need to inform them again that you want to keep the data you had collected. Do this with your rejection email. Add a few sentences to explain why you want to keep the candidate's data. Mention how long you plan to keep their details. Provide a link again to your recruitment privacy notice. Let candidates know they can ask you to delete their data at any time. If they ask you to delete their data, you must comply with that. Prepare to inform candidates of data processing whenever you receive their data. Often you will find yourself possessing personal candidate data through means other than job applications or online sourcing. Candidates may give you their CVs at a career fair or a networking event, or they may ask you to contact them with job opportunities. All these scenarios are lawful under the GDPR, but you need to be able to demonstrate that you have been transparent. You can do this by preparing standard forms that provide all information required by GDPR and ask candidates to sign, or you can email them afterwards with your recruitment privacy notice and the rest of the necessary information. Let's discuss now about reviewing existing talent pipelines. GDPR covers personal data that your company has collected in the past. This means that you must review your talent databases, spreadsheets, and other files where you store candidate data. This is a good opportunity to make sure your talent database is updated and relevant. Determine which candidates may be good matches for future open roles in your company and which are not. If you determine that a candidate is unlikely to be qualified for future roles or is no longer relevant, or you obtained their information too long ago, then you must delete their data. If you store candidate data in your ATS, applicant tracking system, it will be easy to delete the data of those who are disqualified. Take a quick look at all candidate profiles to see if there are candidates who are promising or whom you wanted to contact in the future. You could mass delete the rest. If you'd like to keep a candidate in your talent pipelines, reach out to them to inform them that you are processing their data. For candidates that you want to keep in your database, prepare an email to give them necessary information. This email should be similar to the email you would send to sourced candidates, in that it must include all information about what data you hold and where. These emails should also include links to your privacy policies. Your ATS may have bulk email functions that will make sending this email much easier.
Hi guys, In this lesson, we will discuss about mandatory and voluntary data protection officers or DPOs. Under Article 37, the GDPR specifies that a DPO is required to be appointed by a controller or processor in the following situations. The processing is carried out by a public authority or body except for courts acting in their judicial capacity. The core activities of the controller or the processor consist of processing operations which by virtue of nature, their scope and/or their purposes require regular and systematic monitoring of data subjects on a large scale. The core activities of the controller or the processor consist of processing on a large scale of special categories of data pursuant to Article 9 and personal data relating to criminal convictions and offenses referred to in Article 10. The Working Party 29 has published guidance to further explain these requirements. All public authorities will be expected to designate a DPO, but the Work Party 29 noted that private organizations sometimes may carry out public tasks or exercise public authority in areas such as public transportation, utilities, infrastructure, housing, and broadcasting. These organizations are not required to nominate a DPO, yet they are encouraged to do so, given data subjects have little choice over having their data processed by such organizations. Core activities are those that encompass how an organization makes money and an activity supporting the money-making process. The Working Party 29 cited the use of health data by a hospital as being part of its core activities of providing healthcare services, as opposed to support activities like human resources, accounting, or IT that all organizations would use. Large scale is not defined in the GDPR, but factors do consider include the number of data subjects involved, the volume of data, the different types of data, the permanence of the processing, and the geographic scope of the processing. Hospitals, banks, insurance companies, telecom providers, and ISPs were cited as large-scale processors in the normal course of their businesses. Regular and systematic monitoring is defined to include but not be limited to online tracking and profiling, including tracking used for behavioral advertising. The regular aspect can be ongoing, occurring at regular intervals, or continuous, while systematic would take plan as part of a prearranged according to plan to gather data to achieve a strategy. Telecom services, email and data-driven marketing, profiling and scoring, location tracking, behavioral advertising, CCTV, wearable device monitoring, and smart connected devices, including those comprising the Internet of Things, are all considered to be undertaking regular and systematic monitoring. When an organization does not strictly meet one of these mandated situations, the Working Party 29 believes it is still beneficial to appoint a DPO voluntarily, given the assistance the role provides in complying with the new regulation and the significant increase in creditability with data subjects and data privacy assessments. In either case, the decision to have a DPO or not must then be documented, citing the factors listed above in concluding with the role is required or not and whether voluntary designation will occur. The GDPR requires that a DPO appointed under a voluntary designation has all the same tasks and controllers have the same obligations for the DPO as if the role was required. Hi guys, in this lesson we'll discuss about the skills of a DPO and the GDPR requirements for DPOs. Once it has been determined that a DPO is either required or it is better for business reasons to voluntarily designate one, then it becomes a matter of determining which job skills the person or persons filling the role must have to succeed as a DPO. This is assisted by understanding those competencies required to acquire certification as a DPO. Related to that, but a separate consideration, is which profession is most closely aligned to the skills to fill the role. If a single person is not doing all the DPO tasks, then the controller or processor should decide the different professions that need to be involved in filling the role as part of a team. The GDPR has certain requirements for the DPO, and this reflects directly upon the skills needed by the DPO role, either as a single person or a team. These skills can be summarized into a listing usable by organizations' management and human resources to identify qualified DPO candidates. So, regarding risk and IT, Recital 77 and Articles 39.2 and 35.2 require DPOs to offer guidance on risk assessments, countermeasures, and data protection impact assessments. DPOs must have significant experience in privacy and security risk assessment and best practice mitigation, including significant hands-on experience in privacy assessment, privacy certifications, and information security standard certifications. These skills should be founded upon wide-ranging experience in IT programming, IT infrastructure, and information security audits. While compliance checklists may be helpful, the DPO position first and foremost requires an experienced professional. Because risks constantly evolve, DPOs must demonstrate awareness of changes to the threat landscape and fully comprehend how emerging technologies will alter these risks. Regarding legal expertise and independence, Recital 97 and Articles 37.1, 37.5, and 38.5 specify a person with expert knowledge of data protection law and practices to assist the controller or processor to be bound by secrecy or confidentiality and perform their duties and tasks in an independent manner. DPOs must know data protection law to a level of expertise based upon the type of processing carried out. This signifies that DPOs could be licensed lawyers knowledgeable of not only the GDPR and other relevant European legislation, but also privacy and related laws in all jurisdictions their organization does business or outsources operations. Confidentiality is second nature to the legal profession. DPOs must have experience acting in an independent manner, indicating a need for a mature professional with client relationship and audit experience to handle the delicate task of discovering gaps, encouraging gap mitigation, and ensuring compliance without taking an adversarial position. Regarding cultural and global, DPOs will likely be dealing with controllers and processors from different countries and therefore business cultures. DPOs must have experience in dealing with different ways of thinking and doing business and have the flexibility to marshal these differences into a successful result. Think of the simplified example of an organization with a retail presence in Europe, contract manufacturers in China, IT outsourcers in India, and headquarters in the US. DPOs should be based in the European Union as recommended by the WP29, but also globally focused. Regarding leadership and broad exposure, Article 38.2 requires the controller and processor shall support the DPO by providing resources necessary to carry out those tasks and access to personal data and processing operations, and to maintain his or her expert knowledge. DPOs will need to have leadership and project management experience to be able to request, marshal, and lead the resources needed to carry out their roles. They also must be able to critically assess themselves for knowledge gaps and request training in those areas. DPOs should have broad business experience to know the industries of the data controller and processor well enough to understand how privacy should be implemented to integrate smoothly with the way each company designs and markets its products and services. Self-starter board level. Article 38(3) requires the controller and processor shall ensure that the DPO does not receive any instructions regarding the exercise of those tasks. The DPO shall directly report to the highest management level of the controller or the processor. DPOs should be self-starters with the competence and skills to carry out the role without guidance and to know where to find necessary information. DPOs must also have board-level presence and be able to deal with experienced business people who will not know the intricacies of DPO functions. Licensed external auditors, such as certified public accountants, chartered accountants who audit compliance with laws, standards, and practices, are independent of the auditee and report to the board, would have this type of experience. Regarding common touch and teaching, Article 38(4) allows data subjects to contact the DPO with regard to all issues related to processing of their personal data and to exercise of their rights. DPOs must be able to speak in the language of the average citizen, not in technical or legal jargon, to handle requests and complaints from data subjects. A common touch is helpful to DPOs in their role to protect data subjects' rights. DPOs must also have skills in both legal training and awareness training to ensure all data subjects are aware of their rights and responsibilities and to help train others to assist data subjects on specific requests. Regarding no conflicts and credibility, Article 38(6) allows DPOs to fulfill other tasks if any such tasks and duties do not result in a conflict of interest. DPOs who are members of the data controllers organization may be performing roles that conflict with their DPO role. For example, a DPO also overseeing information security has a conflict when their security risk assessments and treatments are evaluated under their DPO role. Controllers are required to ensure that their DPO is not conflicted. It is best if DPOs are full-time in their role or the role outsourced to an independent external DPO to overcome the possibility of conflicts. Article 39(1) states that DPOs are required to cooperate with the supervisory authority and act as the contact point for the supervisory authority on issues relating to processing. A prior relationship with the DPA is helpful, or DPOs must be able to establish instant credibility with DPAs based upon their wide experience, knowledge, credentials, and relationship skills. Hi guys, in this lesson we'll discuss about a summary of DPO's required job skills. The following list summarizes these requirements into DPO job skills. Significant experience in European Union and global privacy laws, including drafting of privacy policies, technology provisions, and outsourcing agreements. Significant experience in IT operations and programming, including attainment of information security standard certifications and privacy sales or marks. Significant experience in information system auditing, attestation audits, and the assessment and mitigation of risk. Demonstrated leadership skills achieving stated objectives, involving a diverse set of stakeholders and managing varied projects. Demonstrated negotiation skills to interface successfully with DPAs. Demonstrated client relationship skills to continuously coordinate with controllers and processors while maintaining independence. demonstrated communication skills to speak with a wide-ranging audience from the board of directors to data subjects, from managers to IT staff and lawyers. Demonstrated self-starter with ability to gain required knowledge in dynamic environments. Demonstrated record of engaging with emerging laws and technologies. Experience in legal and technical training and in awareness raising. Experience in dealing successfully with different business cultures and industries. Professionally licensed or certified in law, information security, data protection, privacy and auditing, including ethical requirements for competence, confidentiality and continuing education. Current or former European Union resident who is independent and free of any real or perceived conflicts. This view was verified against publications from the network of DPOs for European institutions and the WP29. The former specified at least 7 years of relevant experience, including knowledge of the institution and its data protection practices. It also included the following personal and interpersonal skills. Regarding personal skills: integrity, initiative, organization, perseverance, discretion, ability to assert himself or herself in difficult circumstances, interest in data protection and motivation to be a DPO. Regarding interpersonal skills: communication, negotiation, conflict resolution, ability to build working relationships. The latter extended DPO roles to the Internet of Things and other emerging technologies. DPOs may also have to deal with more complicated issues that are not included in job descriptions. The decision lies with each organization to find these required DPO skills in either a single person or several people, to locate them internally or outsource the role, and to manage this function under the CPO or let it operate independently. CPO is the equivalent of Chief Privacy Officer. It would be optimal to have as many skills as possible in a single individual, for obvious reasons of cost, communication, productivity, and responsibility. It is up to each organization to implement its own DPO role, keeping in mind its obligations and how a DPO will facilitate the likelihood of full compliance with the GDPR. Hi guys, in this lesson we'll discuss about DPO certification. DPOs may be subject to certification in some member states. For example, the Spanish DPA, Agencia Española de Protección de Datos, IAPP, has published guidelines for the certification of DPOs. This certification requires at least 5 years of relevant professional experience or some combination of lesser experience and training. The 4-hour exam covers the areas of data protection laws, including GDPR, the e-privacy directive, the WP29 guidelines, plus relevant Spanish laws, accountability, including risk management and data privacy impact assessments, privacy by design, compliance techniques, including InfoSec, data protection audits, and emerging technologies. Certified DPOs must adhere to a code of ethics and take continuing professional education or training to use the AAPD DPO mark. The stated competencies of advising and supervising tasks for certified DPOs include the following: compliance with principles relating to processing, such as purpose limitation, data minimization or accuracy, identifying the legal basis for data processing, assessment of the compatibility of purposes other than those which gave rise to initial data collection, determining whether any sectoral regulation may determine specific data processing conditions that are different from those established by general data protection regulations, designing and implementing measures to provide information to data subject,
establishing mechanisms to receive and manage requests to exercise rights of the data subjects, assessing requests to exercise rights of the data subjects, hiring data processors, including the content of the contracts or legal documents that regulate the controller-processor relationship, identifying international data transfer instruments that are suited to the needs and characteristics of the organization and the reasons that justify the transfer, design and implementation of data protection policies, data protection audits, establishing and managing a register of processing activities, risk analysis of the processing operations carried out, implementing data protection measures by design and by default that are suited to the risks and nature of the processing operations, implementing security measures that are suited to the risks and nature of the processing operations, establishing procedures to manage violations of data security, including assessing the risk to the rights and freedoms of the data subjects and procedures to notify supervisory authorities and the data subjects, determining the need to carry out data protection impact assessments, carrying out data protection impact assessments, relations with supervisory authorities, and implementing training and awareness programs for personnel on data protection.
Hi guys, in this lesson we'll discuss about DPO professions. To determine which professions to look to fill the DPO role, it is best to start with the GDPR requirements again for the DPO skills, qualities, and tasks. This includes risk assessments, countermeasures, and data protection impact assessments, expert knowledge of data protection law and practices, perform their duties and tasks in an independent manner, not receive any instructions regarding the exercise of those tasks, perform other tasks only if these do not result in a conflict of interest, handle data subject requests, marshal resources and lead people and projects, maintain his or her expert knowledge, bound by secrecy or confidentiality, directly report to the controller-processor's highest management level, and cooperate with and act as the contact point for the supervisory authority or the DPA. Professions matching DPO skills. The two professions appear best suited to carry out the role of DPO, their availability and costs notwithstanding, are experienced privacy and technology focused lawyers and information systems auditors licensed as certified public accountants or chartered accountants. A privacy and technology focused lawyer is a licensed professional with hands-on experience with IT programming and operations, information security audit, privacy certifications, and information security standards, in addition to experience with varied privacy and information security laws, policies, and provisions. Information security auditors would have experience with various types of attestation audits, including privacy and security. Both should have the appropriate professional privacy and information security certifications. Both types of professionals should be able to carry out the following aspects of the DPO role equally well: reporting directly to the highest management level, exercising the tasks of the DPO without receiving instructions, working in an independent manner, and being sensitive to not creating any conflicts of interest. Licensure rules for the regulated professions of lawyer and public chartered accountant both require continuing competence, maintaining integrity, avoiding conflicts of interest, taking sufficient continuing education to maintain his or her expert knowledge, and being bound by rules of professional secrecy and confidentiality. Although lawyers tend to have a broader code of ethics to comply, lack of compliance with their respective ethical rules by those in either profession could lead to loss of their ability to practice publicly. Both professions need to have significant negotiation skills, although given their typical roles, the lawyer will likely have deeper negotiation experience. Both should have knowledge of risk assessments, countermeasures, and data protection impact assessments, although auditors will likely have more in-depth risk mitigation experience. Both may have understandings of privacy by design and default, but the auditor may have more in-depth knowledge through assessing control design. Both should be able to marshal and lead resources teams and projects and handles data subject requests without difficulty. They are able to handle external relationships, communicate effectively with all parties, and educate controller processor personnel and data subjects. What tips the balance between the two is the requirement to have expert knowledge of data protection law and practices, which is something to be expected from the lawyer but not from the auditor. This requirement is more complicated than it appears, as it involves not only the GDPR but other European legislation such as the e-Privacy Directive and relevant cases, but also likely, given the global interplay of organizations, the data protection and relevant other laws and cases of many jurisdictions, and the necessary conflict of laws analysis to determine which laws are controlling. In an independent role, a DPO providing legal advice and analysis who is not a licensed lawyer may also become involved in the unauthorized practice of law. If they instead use the organization's corporate counsel to perform the legal analysis, the DPO may no longer be viewed as independent. Other reasons it is beneficial to have a lawyer in the DPO role include the advantages of legal privilege, competency, and ethical mandates, being able to work easily with corporate and external counsel in the event of enforcement proceedings, and avoiding the unauthorized practice of law. If the DPO is not a lawyer, this means that they are going to be leaning heavily on the corporate counsel, but when doing so, are they still sufficiently independent? Without the DPO's ability to rely on their own legal, IT, audit, and risk evaluations, and not merely accepting those from internal staff, it seems that it would be difficult to maintain the necessary independence and avoid all potential conflicts of interest. That is why, for example, internal accountants prepare financial statements and licensed external accountants audit and opine on those statements based upon their own independent professional judgment, and so should the DPO. Therefore, the best professional to fill the role of DPO under the GDPR would be an experienced privacy and technology-focused lawyer. The privacy and technology focus of this lawyer is essential, as this would not be typical skills of the average lawyer. There are other qualities of a lawyer that also weigh in their favor as the best profession to fill the DPO role, including the use of legal privilege in certain cases when the controller or processor is subject to litigation or other adverse actions, and possibly in their role as a witness or expert in legal cases. Beyond these two professions, it gets more complicated for organizations trying to fill the DPO role with other types of professionals, with multiple people and/or with a combination of internal, hired, and outsourced resources. As a rule, in these types of situations, organizations must stick hard and fast to the following two rules. First, they must not utilize anyone in the DPO role who could create a conflict of interest. For example, a recent case in Germany demonstrated the role of IT manager is inappropriate for the role or DPO under current German law, given the required independence of the DPO from IT operations. Second, any resource filling the DPO role must have sufficient legal and technical skills to carry out an independent assessment of the organization's data protection practices without relying primarily upon the judgment of the organization's staff.
Hi guys, in this lesson we'll discuss about DPO hiring errors. DPO jobs posted in the European Union show some organizations are still learning about the requirements for DPO positions under GDPR. The most common errors are looking for DPOs with too little experience, insufficiently broad job experience, and lack of independence, with DPOs reporting into IT, legal or compliance organizations instead of the board of directors, as GDPR requires. Another error is that organizations assume that their current DPO or similar should be their DPO under the GDPR. That may certainly be valid, but it would be a useful exercise to vet the existing DPO against the job skills discussed before. When discussing the role of the DPO under the GDPR, examples are often cited based upon current experiences under existing legislation, primarily national enactments of the Data Protection Directive. While instructive and possibly the best historical examples that there are in the region, the DPO role under the new GDPR legislation is a somewhat different role, one that may require consideration of what is now required and intended before organizations that already have a DPO automatically slot that person into the role. Another common misconception which many vendors are perpetuating is that you can create a DPO merely with training and certifications without basing it first upon a broad foundation of existing diverse skills gained through years of experience. There is some belief that one can make a DPO out of an inexperienced resource. That is not accurate. What can be accomplished is for an organization to train an existing experienced resource with many of the professional skills and responsibilities discussed in the specifics of the GDPR and hopefully deploy that resource in time into the role, while using an inexperienced resource can be viewed as the way forward for cost or resource constrained organizations. They may be making a choice between full compliance with GDPR and their other business objectives. Given the significant penalty regime of the GDPR, organizations should consider the need to staff the DPO role appropriately from the start to achieve their short and long-term goals. One other problem involves the fundamental flaw of confusing the role of the Chief Privacy Officer (CPO) with that of DPO under the GDPR. The role of a CPO could be described as someone responsible for complying with GDPR from inside the organization, setting policies and procedures to do so, but the new role of DPO is different. The DPO as specified by GDPR must maintain independence and avoid conflicts of interest, in addition to acting as the point of contract, cooperation and consultation with the DPAs. As the WP29 stated, the DPO's primary concern should be enabling compliance with GDPR. It then stated that chief privacy officers or other privacy professionals already in place, who may not always meet the GDPR criteria, for instance, in terms of available resources or guarantees for independence, and therefore cannot be considered and referred to as DPOs. While it is not essential that the DPO must be a lawyer, such a profession helps to address a problem raised by the GDPR. The DPO is required to have expert knowledge of data protection law, and we discussed that in the last lesson. If the DPO is not a lawyer, then this could involve them in the unauthorized practice of law, and again we discussed about that. Another likely issue that must be borne in mind is considering a simplistic legal compliance situation, not the more complex situations when the required expertise in data protection law includes the need to understand, coalesce and possibly apply conflict of law rules to a large list of different laws, regulations and legal cases from different countries, including the privacy and information security laws, consumer protection laws, labor laws, etc. Could this complicated legal work be done without a lawyer in the DPO team? Possibly, but if not, then independent legal counsel would need to be made available to the team.